everybody. This is Gaston Crew for this week's Markman Minute, where we take a look at interesting investor-focused situations that have a intellectual property or patent litigation component to them. You could check out all our content on a weekly basis at mimesislaw.com under the Intellectual Property tab. In addition to prior Markman Minutes, you can also find a weekly newsletter, which we call the Markman Note, that looks at both a big story of the week and litigation events that had an impact on a company or set of companies' share price. So for this week, I wanted to talk about a very interesting situation involving the hot IPO of the past week, and that's Fitbit. Fitbit's a manufacturer of fitness tracking devices, and they went public to much aplomb. The share price has zoomed up since the offering, and at this point, investors must be pretty happy about the direction that the company is going. What I wanted to raise and what I wanted to call attention to is an interesting situation where a competitor of Fitbit actually filed a series of litigations against the company. The first case is a pretty straightforward trade secret case, which was filed by a company called Jawbone, which competes with Fitbit in the market for, we'll call them, wearable fitness tracker devices. And Jawbone filed a complaint arguing that, or alleging that Fitbit had actually poached employees, and that those employees had come over to Fitbit not only with information in their heads gleaned from public sources, but also Jawbone trade secrets. So that case was filed about a month ago at this point, and that was considered an interesting move by a potential competitor to Fitbit. Following the filing of the trade secret case, Jawbone also came forward and filed a set of a patent case, a patent infringement lawsuit in California as well, where they argue that Fitbit is infringing on 3 patents that Jawbone had previously acquired. So now, if you're an investor in Fitbit, I think what you're going to be looking forward to over the next period of time is to see how's the company going to respond to both the trade secret case and the patent case. And I thought that this presents an interesting opportunity to raise a couple of interesting issues that we see quite often. First of all, it's well known amongst the patent bar, and this goes for lawyers that represent corporate clients on the defense or on the plaintiff side, that the period before an IPO is usually a very dangerous time for a company. Competitors in particular tend to look at the upcoming IPO and say, wait a second, we can't just sit idly by and watch our competitor raise a whole lot of money in the capital markets. So it's normally a time where companies are looking at their IP portfolios and seeing, is there anything in here that we can assert against the competitor that's going public? As a corollary to that, you also have a very frequent situation where non-practicing entities or patent assertion companies also look at patents and say, do we have any patents that we can assert against this company going public, because they might be more likely to settle quickly because they don't want any bad news or any bad vibes disrupting their IPO. So one of the things that we tend to caution corporate clients that are considering going public is to expect a raft potentially of intellectual property-based filings against the company as people try to take advantage, A, of the company's newfound liquidity, and B, desire to avoid bad press and bad news in the face of an initial public offering. At the same time, companies that have just gone public tend to be much more flush and capable of fending off intellectual property lawsuits that were filed against them. So one thing to keep an eye out on if you're a Fitbit investor is to see just how aggressive Fitbit is in terms of responding to the cases that Jawbone has filed against it. Now, the trade secret case is usually hard for lawyers like us to follow from the outside relative to a patent case, because there's less public information that we could use to try to handicap the situation. Usually a trade secret case develops over time, and there's a lot of fighting about what the actual trade secret is, and then a focus down the road of, were trade secrets used inappropriately, and what's the damages going to be? So trade secret cases tend to go on a little bit of a slow burn. Fitbit might try to get aggressive and argue from the get-go that there was no appropriation of any trade secrets, a Jawbone, and file a motion to dismiss. But playing a trade secret case out relative to a patent case usually is a little bit of a slower burn. The patent issues that in contrast are a lot easier for us to handicap. I mean, the patents themselves are public documents. We're able to look at the patents, look at Fitbit's products, see whether or not there's a valid infringement read. And I think one of the things that we're going to be monitoring for is not only is to take a look at how the patent case develops in the district court, but whether Fitbit decides to get really aggressive and potentially challenge the validity of the asserted patents in an IPR re-exam proceeding in the patent office. So while Fitbit looks to have successfully gone through the IPO, kind of a legacy of that process seems to be these competitor lawsuits that were filed by Jawbone. And it's going to be an early test of management to see how they handle this case, because I can tell you that other competitors and other patent holders are going to be looking to see just how Fitbit approaches the defense of this case as an indicator of kind of a more general approach to dealing with intellectual property issues going along. The other thing to keep an eye out for is whether Fitbit has patents of its own that it chooses to assert against Jawbone. Now, that would have the effect of potentially setting up a cross-licensing deal and also signal that Fitbit is not, going to be a company that sits around and waits for, damages to accrue against it without taking the initiative in response. In any event, I thought this was a very interesting situation considering the success of Fitbit's IPO, considering the general predilection of companies that are going through an IPO or even in a merger and acquisition situation to have to deal with IP situations. And I think it's going to be an interesting situation to keep an eye out on as these cases develop over time. That's it for this week's Markman Minute. Again, you could check out our content at mimesis.law.com under the Intellectual Property tab. And until next time, be well.